Hello dear students, today we are going to discuss Wrongful Act, Remedies and Damages, Law of Torts. Before going through this lecture, first let's have a look on its objectives. First, the basic principles of Law of Torts. Second, the concept of damage and damages. Third, the remedies available in the Law of Torts. Dear students, first let's understand Wrongful Act. Law in its strict sense means any rule of human conduct enforced by the state, although in its widest sense it includes any rule of human action. Those rules of conduct of persons which are protected and enforced by the state do really constitute the law of the land in its strict sense. Now, damage without injury, that is, damnum sine injuria. There are many acts which, though harmful, are not wrongful and give no right of action to him who suffer from their effects. Damage so done and suffered is called damnum sine injuria or damage without injury. Damage without breach of legal right will not constitute a tort. They are instances of damage suffered from justifiable acts. An act or omission committed with lawful justification or excuse will not because of action, though it results in harm to another as combination in furtherance of trade interest or lawful uses of one's own premises. Now, injury without damage, that is, injuria sine damnum. There are certain cases in which damage is not actionable as a tort, so conversely there are cases in which an act is actionable as a loss, although it has been the cause of no damage at all. In the case of Ashby v. White, the plaintiff has wrongfully returning officers in parliamentary election. The candidate for whom the plaintiff wanted to give his vote had come out successful in election. Still, the plaintiff brought an action claiming damage against the defendants for maliciously preventing him from exercising his statutory right of voting in that election. Chief Justice Lord Holt held that plaintiff is entitled to damage by saying that there was infringement of legal right vested in the plaintiff. Now, dear students, let's understand remedies. There are two types of remedies, judicial and extrajudicial. Judicial remedies are those which are obtained through courts of law, and extra remedies are those which are secured by means of self-help. Of extrajudicial remedies are the right of distress, the right of retaking property, the abatement of nuisance, and the right of retry on land. However, judicial remedies are of three types. First, injunction. Second, damages. And third, specific restitution of property. Now first, let's understand what injunction is. Injunction is an extraordinary judicial remedy resorted to by parties and given effect to by a judge in exceptional cases. Injunction is an order of a court to do or refrain from doing an act. This order is mandatory and restrictive. A prohibitory or restriction injunction is an order restraining the defendant from commuting or repeating an injurious act such as a trespass of land or the execution of a building which will obstruct the plaintiff's rights. There are two types of injunctions, interlocutory injunction and perpetual injunction. An interlocutory injunction is one issued provisionally before the final hearing of the action, or in order to prevent the commission or continuance of an alleged injury in the meantime pending an inquiry into the case and final determination of the right of the plaintiff to a perpetual injunction. A perpetual injunction, on the other hand, is one issued often at the final hearing and determination of the question at issue between the parties. An interlocutory or temporary injunction can only be issued in cases where there is a prayer for a perpetual injunction. Injunctions are often issued either, first, against the continuance of an injury, second, against the repetition of one, or third, against the commission of one. Of these, the first is the most common, under which injunctions are issued restraining parties from continuing to commit a particular nuisance or obstructing a right to light. Again, if a person has once trespassed on my land under a claim of right of way, he may be served with an injunction not to repeat the same wrong. The third type of injunction is called quia timid. It is an injunction to restrain the commission of a tort. In order to maintain a quia timid action to restrain an apprehended injury, the plaintiff must prove imminent damage of a substantial kind, or that the apprehended injury, if it does come, will be irreparable. The plaintiff should satisfy the court that if the defendant is permitted to do the threatened act of digging the well by the side of the plaintiff's double-storied building, irreparable damage will be caused to him by the collapse of the wall near the well. It is obvious that the court will not so readily grant this type of injunction as it will grant the others, for it will require more convincing evidence from a plaintiff as to the harm he thinks he may suffer from the defendant's action than as to the harm he has suffered. One of the basic rules with regard to the issue of injunction is that an injunction should not be granted where damages would form an adequate remedy. The very first principle of injunction law is that prima facie you do not obtain injunctions to restrain actionable wrongs for which damages are the proper remedy. Nor will an injunction be granted where the case is not one of legal injury but of mere inconvenience. Moreover, an injunction will not be granted in a trivial case. Interlocutory injunctions are only granted in the clearest cases and where the plaintiff is able to establish a sufficiently strong case. In the case of Chaitanya Singh versus Maharishi Dayanand Saraswati University, the petitioner, who was a student of B.Ed, allegedly suffered monetary loss, mental stress and strain due to the arbitrary actions of the respondents for which he filed the writ. It was held that the award of compensation for which the writ was filed could not be claimed directly under Article 226 of the Constitution of India, particularly when the alternative remedy of a civil suit was available to a party and it should be available of at the first instance. The appellant having not succeeded in getting compensation for damages against the university, though having succeeded for his admission to B.Ed course and finally succeeded completing the same, could not be said to have been put to any monetary loss which the respondent university could be held responsible. Now, damages in lieu of injunction. Formerly, the Court of Chancery in England had no power to award damages in cases where a party has sought the aid of the court for the issue of injunction. It had no inherent power to award damages for torts, like infringement of right to light, which brought no profit to the wrongdoer. Lord Cairns' Act of 1858 invested the court with power to grant damages in addition to or in substitution for injunction. The torts for which an injunction is usually sought are nuisance, continuing trespass, infringement of copyright, trademarks and patents, and passing off one's goods as those of another. But the remedy of injunction is impossible in the torts of assault and battery, false imprisonment and malicious prosecution. If an injunction is disobeyed by any person, he may be proceeded against for contempt of court and punished by imprisonment and attachment of his property. Now, let's understand specific restitution. Under this form of remedy, the injured party is entitled to recover the specific item of property itself from the wrongdoer. Thus, he who is wrongfully dispossessed of his land is entitled to recover not the value of the land as damages, but the land itself, and a judgment in his favor by force if needed. So, in the case of chattels wrongfully taken or detained, the owner has the option of claiming either their value as damages or specific restitution of possession. Now, tort remedies under public law. Public law remedies have also been extended by the Supreme Court to the realm of tort. The claim in public law for compensation for unconstitutional deprivation of fundamental right to life and liberty, the protection of which is guaranteed under the Constitution, is a claim based on strict liability and is in addition to the claim available in private law for damages for tortious acts of public servants. Now, dear students, let's understand damage and damages, or we can say real and nominal damages. Damage is actual injury or loss. Damages are the sum of money which a person wronged is entitled to receive from the wrongdoer as compensation for the wrong. Damage is the loss which is the cause of the award of damages. Damages recoverable in a tortious action may be either nominal or real. Nominal damages are a small sum of money, for example, a shilling or even a farthing or paisa, awarded not by way of compensation for any actual loss suffered, but merely by way of recognition of the existence of some legal right vested in the plaintiff and violated by the defendant. Real damages, on the other hand, are those which are assessed and awarded as compensation for damage actually suffered by the plaintiff and not simply by the way of mere recognition of legal right infringed. All cases of injuria sine damnum fall under this head. The general rule is that in fixing the sum to be given as damages, the court should as nearly as possible get at that sum of money which will put the party who has been injured in the same position as he would have been in if he had not sustained the wrong for which he is getting compensation. Now, measure of damages. A claimant cannot recover more by way of damages than the amount of his loss. The object of an award of damages is to place the injured party as nearly as possible in the same financial position as he would have been in but for the injury. It has been held in 2 English decisions that when assessing damages in actions for personal injuries or wrongful dismissal for the loss of actual or prospective earnings, allowance must be made for any incidents of income tax including surtax. In the case of Venkatesh vs. City Municipal Council, the plaintiff was the owner of several buildings in Gulbarga town. 3 buildings belonging to the plaintiff were demolished by the officers of the municipality between 10th January and 21st January 1966 for the purpose of broadening the road. Before carrying out the demolition, the municipality did not duly acquire the land with the building under the Land Acquisition Act. The plaintiff brought a suit for recovery of damages for the tortious act of the defendant. The defendants were held liable. The court said, I quote, "One whose interest is immovable property has been injured by the tortious act or omission of another is entitled to those damages which will compensate him for the injury sustained." The goal of the court is to award such an amount of money as will restore the injured party to the same property status which he occupied immediately prior to the injury. It is not possible, however, to state a single rule for damages which applies invariably to cases of this type. Unquote. The 2 rules for damages adopted for injuries to buildings and followed by courts generally are: first, the decrease in market value of the property injuriously affected, and that is determined by arriving at the difference between the market value of the property before and after the injury. Second, to determine the cost of replacing or restoring the building to its condition immediately prior to the injury. If the second rule is followed, the cost of reconstructing the building at about the time of injury is determined and then allowance is made for depreciation, having regard to the age of the building. Interest is awarded from the date of the injury till the date of decree. Injured person's duty of mitigation. The law imposes on a plaintiff the obligation to take all reasonable steps to mitigate the evil. It debars him from claiming any part of the damage which was caused due to his own neglect or lapse. In the case of Marcroft vs. Scrutons Limited, the plaintiff fell down a ship's hatch. The hurt appeared to be not very serious, but he subsequently developed a neurosis which rendered him a nervous wreck. He was advised by a psychiatrist to attend a hospital for treatment. This was not acted upon. The court held that the refusal was unreasonable and it was proper to assess the damage upon the basis that loss subsequent to the refusal must fall upon the plaintiff himself. Now, dear students, let's discuss general and special, pecuniary and non-pecuniary damages. Courts very often award damages. However, these are of 2 types, general and special damages. General damages are compensation for general damage, special damages for special damage. This distinction arises more out of the burden of proof of the parties in the conduct of the case. General damage is that kind of damage which the law presumes to follow from the wrong complained of and which therefore need not be specifically mentioned in the plaintiff's pleading. Special damage, on the other hand, is a damage of such a kind that it will not be presumed but must be specially set out and proved by the party who claims it. The party who claims any special damage must specifically state and prove the particular damage which he has sustained arising out of wrongful act of the concerned party. Thus, in an action for false imprisonment, general damages are recoverable in respect of the inconvenience, indignity and discomfort so suffered by the plaintiff. For these are the natural and normal results which the law presumes to follow from any injury of the description. But if the plaintiff by his imprisonment incurred medical expenses or has suffered any specific pecuniary loss such as the loss of wages, this is special damage which must be expressly alleged and proved, otherwise compensation cannot be recovered in respect of it. The court, quoting from Halsbury's Laws of England, approved the following two types of damages as detailed items. General damages. First, mere injury to feelings. Second, the illness of the plaintiff, illness not being a natural result of the defamatory words. Third, illness of any other person. Fourth, the death of any other person. Fifth, the mere loss of the society of acquaintances as contrasted with the material loss of hospitality. Sixth, any damage not pecuniary or capable of being estimated in money. Seventh, the loss of membership of some society or congregation constituted for religious purposes, the membership of which does not carry with it material temporal advantages. Special damages. First, loss of consortium of husband. Second, loss of marriage. Third, loss of material hospitality, loss of employment. Fourth, loss of particular customers. Fifth, loss of dealing even though it might have turned out unprofitably. Sixth, general falling off of profits. Seventh, any other material loss. With special reference to defamation, it is stated that Halsbury, apart from general damages for injury to reputation, special damages in the strict sense of lie term may be awarded, if expressly claimed in respect of any material temporal injury proved to have been suffered as the natural result of the defamatory publication complained of. Special damage is the loss of some material temporal advantage, pecuniary or capable of being estimated in money, which flows directly and in the ordinary course of things from the act of the defendant or an act for which he is responsible. In determining the amount of damages that the defendant should pay for the injury caused to the plaintiff goods, it is no concern of the defendant what the plaintiff was doing with the goods. If you wrongfully take away my chair and keep it for a year, it will not help you to show that I did not usually sit on the chair. In serious cases, it is the practice to present very detailed schedules of future expenses, and awards under the head can be very large indeed, often much larger than those for loss of earnings. Now, dear students, let's understand pecuniary loss, deduction of benefits received. In contract as well as in tort and in non-personal injury cases, the modern approach is to ask whether the benefit received is sufficiently causally connected with the defendant's wrongdoing so as to require it to be brought into account. Where legislation provides a complete code of deductibility, there can be no deduction except as specified in it. Now, dear students, let's understand contemptuous damages. These damages mark the disapproval by a court of the conduct of a successful plaintiff. It is equivalent to the judge saying to the plaintiff, "You are technically right but morally wrong." In such cases, the chances of getting costs are very little for the successful plaintiff. He too comes before the court with unclean hands, and his conduct is equally blameworthy as that of the defendant. Thus, in the case of Kelly versus Sherlock, where the defendant in his newspaper had libelled the plaintiff in very bad terms, but the plaintiff had retorted with a counter-attack equally bad and base. He spoke of the defendant's newspaper as the dregs of provincial journalism. The plaintiff got only a farthing as damages. Where contemptuous damages are awarded, it generally means that the defamatory statements are so nearly true that very small damages will suffice, or that the plaintiff's character is so bad that contemptuous damages should be given. In such a case, the action should be regarded as oppressive, and that it should never have been brought, and therefore good cause exists for depriving the plaintiff of his costs. Now, dear students, let's understand vindictive or exemplary or deterrent damages. These types of damages are awarded by court when it views with extreme displeasure the wanton misconduct of the defendant in utter disregard of the plaintiff's rights. The plaintiff may not have sustained any material loss, still in order to make an example of the defendants so that other similar-minded persons should not attempt to do similar wrongs. judges usually award by way of punishment a higher amount as damages to the injured plaintiff. So in an action by a father for the seduction of his daughter, the only actual loss which gives him a right of the action is the loss of his daughter's services. Yet damages are not limited to the amount of this loss, but much higher sums are awarded in respect of the injury to his parental feelings and personal dignity. If a male student kisses a female student against her consent, although the latter has not sustained any material loss, still in an action for assault, the injured lady student will be able to get exemplary damages against the wrongdoer. In such cases, exemplary damages represent a solatium for the outrage to the plaintiff's feelings or the insult given to the injured party. The court awarded exemplary damages on top of an account of profits for breach of fiduciary duty. In tort cases, the court usually has to decide three questions. First, was the damage caused by the defendant's wrongful act? Second, was it remote? And third, what is the monetary compensation for the damage? Now, dear students, let's understand the various classes of cases where damages are irrecoverable. Damages are irrecoverable in the following four classes of cases. First, cases of damnum sine injuria. Second, damnum suffered by one person and injuria by the another. Third, damnum of a kind not recognized by law. And fourth, damnum to remote. Of these, the first and the last have already been explained before and as such require no further explanation. By way of additional examples of the first category, besides the damage due to competition in trade, we may cite further illustrations of damage done by the withdrawal of light or support from buildings not entitled to an easement of light or support or withdrawal of underground water. In the second class of cases, the defendant is not liable for his act to the plaintiff for the reason that no duty is owed to the latter. In the third type of cases, the law does not recognize and give compensation for the damage suffered by the plaintiff. Thus, under the English common law, no damages can be recovered for the death of a human being. Again, when the plaintiff's cause of action is based on the provisions of some statute, it is not enough that the plaintiff has suffered damages as a result of the breach of any statutory provision, but it is also necessary that the plaintiff should have been one of those persons whom the statute has intended to afford protection by its sediment. Dear students, this was all about today's program. Hope you have enjoyed the session. For now, it's time to say goodbye. Stay blessed.